Have you ever thought the organization meant to maintain order in your neighborhood could be the biggest threat to your family's home? Today I'm going to tell you an unbelievable story about how a HOA Karen literally stole my sister's house and sold it illegally, but don't worry, they ultimately paid dearly for their actions. Let me introduce you to the main characters in this drama: myself, a professional attorney who never imagined I'd have to defend my own family; my sister Sarah, a 32-year-old dedicated nurse who worked tirelessly to afford her dream home; and Karen, the 48-year-old HOA board president whose hunger for power and entitled attitude would lead to the biggest mistake of her professional career. This story begins in what seemed like an idyllic suburban neighborhood, where manicured lawns and strict HOA rules promised a perfect community. Little did we know that beneath this picture-perfect facade lurked a web of deception and abuse of authority that would turn our family's American dream into an absolute nightmare. What started as routine HOA violations would escalate into a full-blown criminal conspiracy that shook our entire family to its core. The nightmare began when Sarah decided to take a year-long nursing position at a specialized trauma center 3 states away. It was a career opportunity she couldn't pass up, but she was worried about leaving her beautiful 2-story colonial home that she'd worked so hard to afford. Being in a HOA-controlled neighborhood meant maintaining certain standards, and she knew the rules were strict. Sarah found the perfect solution in her best friend Jessica, who was between apartments and needed a place to stay. They arranged for Jessica to house sit, take care of the garden, and ensure everything remained in pristine condition according to HOA standards. For the first few months, everything seemed fine. Jessica sent regular photos of the immaculate lawn, the well-trimmed hedges, and even pictures of herself painting the front door the exact shade required by HOA guidelines. Sarah felt relieved knowing her investment was in good hands. However, unbeknownst to her, Karen had been watching the house like a hawk. Karen had developed an obsession with power during her 5 years as HOA president, and she particularly enjoyed finding violations where others might miss them. She began taking daily photos of Sarah's property, documenting every blade of grass that grew a millimeter too long, every leaf that fell from the oak tree in the backyard. The first warning letter arrived in Sarah's mailbox at her temporary address in Colorado. It stated that her grass exceeded the maximum height of 3 inches by approximately half an inch in several spots. The fine was $150. Sarah immediately called Jessica, who was confused because she had just mowed the lawn the previous weekend. Nevertheless, Sarah paid the fine and asked Jessica to be more vigilant about lawn maintenance. The second letter came 2 weeks later, this time complaining about a small oil stain on the driveway from a delivery truck. Another $200 fine. Then came complaints about the mailbox being slightly tilted, the house numbers needing repainting, and various other microscopic infractions. Each time Sarah received a letter, she would call Jessica, who became increasingly frustrated. "I'm doing everything by the book," Jessica insisted. "I have the receipt from the landscaper, I cleaned that oil stain the same day, I even had the mailbox straightened and mounted properly." Sarah began to suspect something was wrong, but she was 3 states away and completely dependent on what she was being told. She tried calling Karen directly several times but was always told she was unavailable or in meetings. The situation escalated dramatically when Sarah received a letter stating she was in chronic violation of HOA rules and had 30 days to resolve all issues or face more serious consequences. What made this particularly suspicious was that some of the violations listed had supposedly occurred after they were corrected. For instance, the letter claimed the grass was overgrown on Tuesday when Jessica had photos proving she had mowed it on Monday. Sarah documented everything, took screenshots of text messages with timestamps, and compiled a formal complaint against the HOA. Her complaint disappeared into thin air. When she called the HOA office, she was told they had no record of receiving it. When she sent it by certified mail, the signature showed it was received by Kaya Peterson. Karen's full name was Karen Peterson. Sarah then tried to attend HOA meetings virtually, but was told proxy attendance wasn't allowed for property owners under review. She was effectively being stonewalled at every turn. Meanwhile, Karen had been busy orchestrating something far more sinister. She had discovered that Sarah's property had appreciated significantly in value and was now worth nearly $450,000. More importantly, she had found a legal loophole in the state's HOA regulations. If a property owner was deemed to have abandoned their residence for more than 6 months with chronic violations, the HOA could initiate a forced sale to recover accumulated fines and legal fees. This law was designed to handle truly abandoned properties, not temporary relocations for work. Karen began building her case methodically. She hired a private investigator to confirm Sarah wasn't living at the property. She documented every violation, real or imagined, with professional photography. She even arranged for numerous final notice letters to be sent simultaneously, creating a paper trail that suggested Sarah was ignoring multiple warnings. What Sarah didn't know was that some of these letters were being intercepted before Jessica could collect them from the mailbox. The coup de grace came when Karen discovered that Pinnacle Properties, a real estate investment company, was actively buying properties in their neighborhood for cash. The company was run by her brother-in-law, though she never disclosed this connection to the HOA board. She presented a compelling case to the other board members, painting Sarah as an absentee landlord who was destroying property values with her negligence. The board, trusting Karen's leadership and intimidated by her legal expertise, voted to proceed with forced foreclosure. 8 months into Sarah's assignment, she received the most devastating letter of her life. It informed her that due to chronic violations and abandonment, her property was being seized by the HOA and would be sold at auction in 2 weeks to recover fines totaling $12,847, an amount that seemed impossible given the individual violations she'd been charged. When she tried to call, she learned her number had been blocked for harassment. Emails bounced back as undeliverable. It was as if the HOA had declared war on her. Panicked, Sarah immediately requested emergency leave from her position and drove straight through the night to get home. What she found when she arrived made her physically sick. There was a for sale sign on her lawn, and strangers were walking through her house that Jessica was still supposed to be living in. She found Jessica staying at a motel, crying and confused. Jessica explained that 3 weeks earlier, the HOA had changed the locks and posted a notice that the property was under HOA control pending sale. Sarah burst into tears on her front lawn, which was when she called me. As her brother and a lawyer, I had been peripherally aware of her HOA troubles but hadn't realized the severity until that moment. Her tearful call at 2 a.m. will haunt me forever. "They took my house," she sobbed. "I don't understand. I did everything they asked. I paid all the fines. How is this even legal?" That night, I began what would become a 6-month investigation into one of the most outrageous abuses of HOA power I've ever encountered. I started by reviewing every piece of correspondence Sarah had received and every payment she had made. Right away, I noticed discrepancies. Many fines were for violations that weren't actually in the HOA bylaws. Others were for the same violation multiple times, suggesting double or triple billing. I then requested all HOA records related to Sarah's property. The HOA initially refused, claiming attorney-client privilege. I had to threaten legal action just to get basic information. When the documents finally arrived, they revealed a pattern of harassment that was shocking even to someone who's seen plenty of HOA overreach. Karen had been taking photos of Sarah's property sometimes 3 times a day, looking for any possible violation. The breakthrough came when I discovered the connection between Karen and Pinnacle Properties. A quick corporate filing search revealed that Thomas Pinnacle, the company's owner, was married to Karen's sister. This was never disclosed to the HOA board or to Sarah. Under our state's HOA regulations, board members must recuse themselves from votes involving potential conflicts of interest. Not only had Karen failed to recuse herself, she had actively pushed for the foreclosure. But the smoking gun was yet to come. Through a Freedom of Information Act request, I obtained records from the county clerk's office that showed Pinnacle Properties had inquired about buying Sarah's property 6 months before the foreclosure proceedings began. They had specifically asked about HOA foreclosure procedures and timelines. This suggested the entire sequence of events had been orchestrated from the beginning. I gathered affidavits from other homeowners in the neighborhood who had received similar harassment from Karen. It turned out that 5 other properties had been forced into HOA foreclosure over the past 3 years, with 4 of them ending up purchased by companies with undisclosed connections to HOA board members. The pattern was clear: this was a systematic scheme to acquire properties below market value. Armed with this evidence, I filed a comprehensive lawsuit against the HOA, its board members, and Pinnacle Properties. The charges included fraud, conspiracy, abuse of process, and violations of state HOA regulations. I also filed complaints with the State Real Estate Commission and requested a full audit of the HOA's finances. The legal battle was intense. Karen and the HOA hired a powerful law firm known for defending HOA boards. They tried every tactic possible to dismiss the case, claiming sovereign immunity, statute of limitations, and procedural errors. But the evidence was overwhelming. As discovery proceeded, we uncovered email communications between Karen and her brother-in-law discussing target properties and strategies for encouraging turnover. The breakthrough moment came during Karen's deposition, 6 months into the legal battle. Under oath, she was forced to admit the timeline of events that proved her conspiracy. When my co-counsel asked her about the email dated 3 months before Sarah left town that said, "Pinnacle is ready to move on the nurse's property whenever you give the signal," Karen's face went ashen. She tried to claim it was taken out of context, but the follow-up emails made clear reference to creating conditions for foreclosure and manufacturing violations. Her attorney called for a recess, and I knew we had them. The next week brought even more devastating revelations. The HOA's accountant, feeling the weight of potential criminal charges, came forward with evidence of systematic financial fraud. He provided spreadsheets showing how fines had been artificially inflated, how maintenance fees had been diverted to pay for legal costs related to foreclosures, and how board members had received kickbacks from property sales. The numbers were staggering. Over $2.3 million had been siphoned through fraudulent foreclosures in the past 5 years. Sarah's case was just the tip of the iceberg. We discovered that the Peterson family had essentially turned the HOA into a personal real estate empire. Karen's husband owned a property management company that had exclusive contracts with the HOA at inflated rates. Her son was the preferred contractor for all HOA repairs, charging well above market prices. The family had even purchased foreclosed properties through shell companies and flipped them for enormous profits. The state attorney general's office took notice when our lawsuit made headlines. A criminal investigation was launched, with FBI involvement due to mail fraud and wire fraud charges crossing state lines. Karen's home and offices were raided, computers seized, and financial records subpoenaed. The scope of the investigation expanded to include other HOAs managed by the same law firm, revealing a multi-state conspiracy involving dozens of HOA boards. Meanwhile, the community response was overwhelming. Homeowners who had been living in fear of Karen's regime for years finally felt safe to speak out. Social media exploded with #HOAgate, and our story went viral on platforms like Reddit and TikTok. Local news stations picked up the story, with investigative journalists uncovering similar schemes in neighboring communities. The pressure on the HOA became unbearable. 3 months before trial was scheduled to begin, the HOA's insurance company stepped in. They had been monitoring the situation and calculated that a trial would result in damages far exceeding their policy limits. They pressured the HOA to settle immediately. Pinnacle Properties, facing multiple lawsuits and criminal charges, had already filed for bankruptcy protection. The entire house of cards was collapsing. In a dramatic courtroom session, Karen broke down completely. Her attorney had advised her to take a plea deal, and part of that deal required her to make a full confession. Through tears, she admitted to orchestrating the entire scheme, targeting homeowners she perceived as vulnerable, and using her position of trust to enrich her family. She expressed what appeared to be genuine remorse, stating that what started as wanting to maintain property values had spiraled into greed and abuse of power. But the most shocking revelation came when she named other involved parties. Several city council members had been aware of the scheme and had received campaign contributions in exchange for their silence. A judge who had rubber-stamped many of the foreclosure orders was found to have financial ties to the same law firm representing the HOA. The corruption extended far beyond what anyone had imagined. The settlement negotiations were swift and decisive. The HOA agreed to return Sarah's property immediately, with all modifications and improvements made during their possession to be maintained at their expense. They paid for all moving costs, legal fees, and provided comprehensive compensation for emotional distress. The monetary settlement exceeded $430,000, more than the total value of Sarah's home. Additionally, they agreed to new HOA bylaws that included elected board positions, term limits, mandatory financial audits, and strict conflict of interest policies. Pinnacle Properties, despite their bankruptcy filing, had assets seized and liquidated. Their legitimate properties were sold, with proceeds going to a victim compensation fund. Thomas Pinnacle faced not only civil penalties but criminal charges that resulted in a 5-year prison sentence. The law firm that had been representing multiple HOAs in these schemes lost their license to practice law in our state. For Karen herself, the consequences were severe and comprehensive. Criminal charges included fraud, conspiracy, extortion, and abuse of public trust. Her plea deal resulted in an 18-month prison sentence, 3 years of probation, and a lifetime ban from serving on any HOA board. She was required to personally pay additional restitution to victims beyond what the HOA covered. Her husband's property management company lost all its contracts and eventually folded. The family lost their own home, which ironically was in the same neighborhood where they had terrorized others. But the ripple effects went far beyond individual punishments. The state legislature introduced comprehensive HOA reform legislation, dubbed Sarah's Law in honor of my sister. This law mandated transparency in all HOA operations, required board members to undergo training on fiduciary responsibilities, established an ombudsman's office for HOA complaints, and created strict penalties for conflict of interest violations. Every HOA in the state was required to undergo a comprehensive audit within 12 months. The media attention brought national awareness to HOA abuse of power. Congressional hearings were held, with Sarah testifying before a House subcommittee about the need for federal oversight of HOA boards. Her testimony was particularly powerful when she broke down describing the emotional trauma of losing her home and the months of gaslighting she endured. The chairman of the committee promised that federal action would follow. For our family, the victory was bittersweet. While Sarah got her house back and received significant compensation, the emotional scars ran deep. She struggled with anxiety for months, unable to trust her own perceptions after being gaslit so extensively. She eventually moved to a different neighborhood, unable to feel safe in the place where her nightmare unfolded. However, she channeled her experience into advocacy, becoming a nationally recognized expert on HOA reform. The other victims of Karen's scheme received justice as well. The elderly couple whose property had been foreclosed received their home back and substantial compensation for the care facility costs they had incurred. The young family who lost their starter home received enough compensation to put down payment on a larger house in a better neighborhood. Each victim's story was unique, but the pattern of abuse was chillingly similar. The neighborhood itself underwent a complete transformation. With the old HOA board removed, residents elected new leadership focused on reasonable governance and community building rather than harassment and enrichment. Property values actually increased as word spread that the toxic HOA had been cleaned out. Block parties were organized, community gardens were established, and neighbors who had lived in fear for years began to connect with each other. 1 year after the settlement, Sarah hosted a neighborhood barbecue at her home. Former victims, new board members, and residents who had stood by silently during the abuse came together. The symbolism wasn't lost on anyone. The same lawn where Karen had measured grass blades with a ruler was now filled with laughing children and neighbors sharing stories. Sarah gave a short speech, thanking everyone who supported her fight and emphasizing that the real victory was creating a community where people looked out for each other rather than looking for violations. The legal precedent set by our case inspired dozens of similar lawsuits across the country. Law firms specializing in HOA abuse cases reported a 400% increase in inquiries. State after state began reviewing their HOA regulations, with many adopting versions of Sarah's law. The American Bar Association created a special committee to study HOA governance and recommend best practices. Karen served her prison sentence in a minimum security facility. According to reports, she spent much of her time in the law library, apparently working on what she claimed would be a book about HOA reform. Many people scoffed at the idea that she was suddenly an advocate for change, but others felt that her inside knowledge could be valuable in preventing future abuses. She was released after 14 months for good behavior, entering a halfway house program in a different state. 2 years after the ordeal began, Sarah received an unexpected letter. It was from a resident of a HOA in Florida who had read about her case. This person was experiencing similar harassment and asked for advice on how to document and fight back. Sarah realized that while her personal battle was won, there were countless others still trapped in similar situations. She founded a nonprofit organization, the HOA Transparency and Accountability Project, providing resources and legal referrals to homeowners facing board abuse. The final twist in our story came 3 years later. Sarah won a landmark case at the state Supreme Court that established homeowners' constitutional rights to privacy and due process in HOA proceedings. The court ruling specifically cited the trauma she endured and stated that HOA boards cannot operate above the law simply because they're private organizations managing common areas. This decision became a template for similar rulings across the nation. Today, when people ask Sarah about her experience, she acknowledges the pain but emphasizes the positive changes that resulted. Her voice carries the authority of someone who fought a system and won, but also the compassion of someone who knows what it's like to feel powerless. She's become a sought-after speaker at real estate conferences and legal seminars, always ending her presentations with the same message: HOAs can serve a valuable purpose, but power without accountability is always dangerous. My nightmare became my mission, and together, we can ensure this never happens to another family. As for me, this case forever changed how I practice law and view community organizations. I've since specialized in property rights and HOA law, pro bono cases that might otherwise go unheard. Every lawyer has cases that define their career. Sarah's case became my calling. The little sister who called me crying at 2 a.m. became the inspiration for systemic change that protected thousands of homeowners across the country.